Does a trust need its own bank account? My name is Michael Pevney. I am an estate planning lawyer in Southern California, and I create estate plans for California families. If you or anybody else that you know want to talk to me for free about setting up their own estate plan, you can set up a time to speak with me by going to my website. The link should be in the comments section. So a trust needs to be funded in order for it to be a valid, a legal trust. In California, that means putting something in the trust. And remember, a trust is a legal document that you create, or you create hopefully with the help of a qualified attorney, and that says what you want to happen with your stuff, your property, both while you're alive and then after you pass away. But after a trust is created, we have to put things in the trust. We have to fund the trust. For many people, especially homeowners, we want to make sure that real estate gets into the trust. If it's real estate anywhere in the U.S., not Puerto Rico, I learned recently, but certainly in any U.S. state, we can fund the trust with that real estate. We file a deed with the county in where the property is, placing the home from your name or your name and your spouse's name into the trust with typically you or you and your spouse as the trustees, meaning the people that are in charge of that trust. But oftentimes we need to either retitle other financial accounts, open a financial account, and or make the beneficiary of a financial account the trust. So typically what I tell my clients when we initially set up, sign, and officially notarize their trust, that it's going to be a good idea to open a bank account in the name of the trust. Now, in order to open a bank account in the name of a trust, you're going to need three things: a name, a date, and a tax ID number. Now, the name of the trust is whatever you want, whatever you have named the trust. So I'm married to Heather. We could just name it the Michael and Heather Living Trust. The date of the trust is going to be the date that the trust came into existence, right? So it's often going to be the date that it was signed and notarized. So I'll just use my birthday, for example. So it would be the Michael and Heather Trust, dated July 20th, 1981. And then third, in order to open a bank account in the name of the trust, you're going to need some sort of a tax ID number. For most of my clients, I set up a living trust, which means it is not just a living trust, a revocable living trust, which means that you or you and your spouse have complete control over it. You can change it anytime that you are alive. And typically a revocable living trust does not have its own tax ID number. Its tax ID number is your social security number or your spouse's social security number. So it does not need its own tax ID number, much like a business might. Or sometimes an irrevocable trust might need its own independent tax ID number. So essentially, after you set up the trust, my clients walk out of the office with their original trust documents in hand. It's in a folder, there's dividers, that whole sort of thing. And I give them instructions. And I say, you go to your bank. Don't just walk in one day and surprise the teller with this. You're going to need to make an appointment and just bring the entire folder with you that's going to have a couple of documents in it, one of which they will likely need to see. So there's the trust itself, or better, the certificate or certification of trust. It's basically kind of a shortened version of the trust. It says that a trust exists, that you're in control of it, that you are the current trustee. It might name the secondary or alternate trustees as well. And so you show them those documents. You open that checking account probably in the name of the trust. That account, you don't necessarily have to put a whole lot of money into it, maybe a few $100s or something like that. You want it to be linked to any other accounts that you have at that financial institution. I certainly don't endorse any specific banks, but every big bank and large credit union is going to be able to do this for you, and they should be familiar with the process. They should be dealing with trusts fairly regularly. So why do we have this account? Why do we open a bank account in the name of the trust? Here's why. If you pass away and there's real estate in the name of the trust and that real estate gets sold, guess who the check's going to be written to? It's not going to be written to you. You're dead, and we don't want to have to deal with that. It's not necessarily going to be written to your kids, because we want sometimes special provisions in the trust for how things are going to be left to the kids. It's going to be written, the check, whatever money's coming from that home, is going to be written to the trust. So we want at least one account, one bank account, as sort of a, call it a clearinghouse, where funds can go after you've passed away and can now be distributed according to the terms of the trust. And so those are just a couple of the basics about why I think a trust, a revocable living trust, should have at least one bank account opened in the name of the trust while the people that created the trust, the grantors or the trust makers, are still alive. So that's just a little overview of that. Once again, my name is Michael Pevney. I'm an estate planning lawyer in Southern California, and you can visit my website at ocestateplanlawyer.com. Obviously, subscribe to this page, follow me on all of my social media sites, and I've got a lot of video information out there. Thanks for your time.